So those are the basic provisions for search warrants, and of course with most kinds of existing electronic information, a search warrant is always a possibility and is always an option and is always potentially available if the government is able to show the required probable cause and get the warrant from a judge. Now on this chart I have 4 other possible means of obtaining electronic information in a criminal investigation. The first of these is the wiretap, and the wiretap actually requires a higher showing than an ordinary search warrant, and we'll talk about that in just a moment. The other 3, the Stored Communications Act, Pen, Register, Trap and Trace, and National Security Letters, require a lower showing, and in some cases a far lower showing than a search warrant, and we'll talk about those as well. So let's talk first briefly about wiretap. I gave you the wiretap statute to read, and what you should gather from looking at the wiretap statute and looking at the whole scheme, kind of putting it all together. The search warrant and these other means that we list here are either obtaining existing records or obtaining information about communications. The wiretap statute relates to obtaining communications that are in transit. And because a communication that is in transit, or if you want to think about it in terms of not electronic evidence but ordinary evidence, simply just say a conversation over an ordinary phone line, which is really sort of the part of the original basis of the need for wiretaps. That kind of communication in transit is seen as having a heightened level of constitutional protection. If a record is created, the record is there, it's created, the privacy interests, the Fourth Amendment privacy interests, and the speech interests, and the associational interests under the First Amendment aren't quite as strong as they are in the case of communications in transit. At least that's the way the law has looked at it. And so therefore the law has developed to require, and the statute requires, really what you might consider a super warrant in order to get a wiretap order. So the showing that has to be made for a wiretap order is the probable cause standard under the Fourth Amendment, plus a showing that normal investigative procedures have failed or will likely fail or are too dangerous. And so often what the showing that has to be made is that the communication is ephemeral. So you're talking on the telephone, there's no other recording of it being made, and the evidence is just going to sort of disappear into the mist once the words are spoken, unless it's captured. That's kind of a typical case in which you might show that normal investigative procedures, that is obtaining existing records or obtaining testimony, are likely to fail. So wiretaps can apply to spoken communication. They also potentially can apply to electronic communication. So capturing keystrokes in real time, for example, when people are writing emails or communicating in chat rooms. That sort of thing likely requires a wiretap order and requires this higher showing. So the next piece that we will talk about briefly is the Pen, Register, Trap and Trace and the National Security Letters, and then we're going to go back and talk about the ECPA and the Stored Communications Act. So a pen register or a trap and trace is a term for devices that traditionally would capture incoming or outgoing telephone dialing information. And literally in the original days of these kinds of procedures, you would put a physical device on a phone line and actually literally tap it into the phone line, and it would not capture the voice content going over the lines. All it would capture is the numbers that were dialed, either going out or a number coming in. Now this did come a bit into the electronic age because it was not simply a rotary telephone device, but it was in a time when you had push-button telephones as well. But nevertheless, it was seen to have a lower privacy interest than even other kinds of information that you might otherwise require a search warrant for. And so in order to be able to place a pen, register, or trap and trace device and obtain this dialing information, all that is required is a court order. Not a warrant, but a court order. Now, you still do have to go to court and get the court to issue the order, but notice in the right-hand column under limitations that the showing that has to be made is much lower. So instead of having to show probable cause, like you have to show for a search warrant, you only need to show that the information likely to be obtained is relevant to an ongoing criminal investigation being conducted by the requesting agency, and you don't have to give any notice to the subscriber. So as you can imagine, it's really not hard to show that the information might be relevant to an ongoing criminal investigation. That relevance standard obviously is a very broad standard. Now, why was it thought that this kind of information entailed a lower expectation of privacy than communications in transit, or even than the kinds of information that otherwise would be subject to a search warrant on probable cause? And the reason is that the information is actually passing through, in the days of original kind of telephone lines, was passing through the telephone company, was passing through a third party. Now, there is in constitutional law of criminal procedure in the Fourth Amendment something called the third party doctrine. And the third party doctrine has to do with what sorts of expectation of privacy someone might have in information that is disclosed to a third party. And generally speaking, if information is disclosed to a third party, then the discloser of that information has given up the expectation, any expectation of privacy in that information. So if I say to you, hey, tomorrow I'm going to rob the bank, and the government tries to get me to testify that I said that, I can plead the Fifth Amendment. I don't, I have a right against self-incrimination. I have privacy interests. But if they subpoena you, I can't prevent you from testifying about that. I've disclosed that information to you. I've given up my expectation of privacy in that information. You might have your own right of self-incrimination or something along those lines, but I have given up my right of privacy. That's the general principle. There are various exceptions to it. But here with the pen, register, trap, and trace, because it's going over phone lines that the subscriber does not own and that the phone company owns, you've given up the expectation of privacy in those numbers. So the same kind of principle can apply to electronic routing information. And that is not content information, but routing information. And we'll see that also when we talk about the Electronic Communications Privacy Act and the Stored Communications Act. All right, the last category that I want to mention before we talk about the ECPA and SCA is national security letters. The national security letters are extremely controversial, and were also sort of part of the package of things. If you took the national security, cybersecurity course, you'll recall talking about this briefly, and also talking about, of course, the FISA statute and other procedures through which the government has conducted and still conducts, in some respects, surveillance of electronic communications and on the internet. And the national security letters were one aspect of that. So this allowed the FBI to issue a letter to a telecommunications service provider, requiring the provider to supply to the FBI subscriber information, toll billing records, and other transactional records. And these transactional records would not include content. So if it was content in transit would require a wiretap still. If it was stored content, it would require the kinds of orders under the Stored Communications Act that we'll look at in a moment. But notice here, it didn't require any kind of court oversight at all. It doesn't require any, this is still the law, it doesn't require any kind of court oversight at all. The FBI can simply issue the letter. Now, the FBI has to, in order to have the authority to issue the letter, has to assert that the information is relevant to an authorized investigation to protect against international terrorism or related to clandestine intelligence activities. There is no disclosure to the subscriber of this process happening, but there is a procedure for the ISP to challenge it if the ISP wants to challenge it. So this has been and is and remains very controversial. It is still widely used, and I think it raises issues for us as lawyers, certainly from my perspective, because it lacks any sort of judicial oversight. Even the Pen Register and Stored Communications Act and these other provisions at least usually require some kind of judicial oversight.